I want to deal with one of the points that have run through this lecture so far, and it's a term I've been using quite a lot, and I want to take this opportunity to just say a little bit more about it. I've been referring to judicial lawmaking because that, I suppose, is my opinion on what is happening here. Now, if you were to study law, you would see that there's quite a large debate on the nature of judicial lawmaking and also the legitimacy of judicial lawmaking. I'm proceeding on the basis, because I think it's the most accurate reflection of contemporary practice of judges in the United Kingdom, that we are looking at judges making law. And the question is, what are the parameters of this practice? What are the legitimate parameters of judicial lawmaking? It's related, as you might guess, to the themes that we've been looking at around the hierarchy of courts and around the questions of the flexibility and development of the common law. To relate this back to one of the important points that we dealt with in an earlier lecture, the point that we have to confront and consider is the relationship between Parliament and judges. As we know, Parliament is sovereign. Parliament is the supreme lawmaking power. Now, this doesn't mean that judges don't make law. It means that they have a subordinate lawmaking power. I'm going to use, if I have to just back this argument up, I'm going to use a reference to Hart's book, The Concept of Law, which I've also mentioned in an earlier lecture, where Hart more or less admits that a legal system can have a number of what he calls rules of recognition. In other words, rules that allow us to identify the rules of the legal system. Now, a legal system can have a number of rules of recognition, provided that there is one supreme rule of recognition. The supreme rule of recognition in the UK Constitution, or in English law, is, the law of the United Kingdom, is that that Parliament is sovereign. The Crown in Parliament is sovereign. That has supreme lawmaking power. This doesn't mean, though, that the judges can't themselves have a subordinate lawmaking power. All this means is that it's consistent with the general statement that there are two sources of common law, i.e. the law made by Parliament and the law made by judges. To avoid confusion, I'm of course referring to common law there as a family of law, in distinction, say, to civil law, as a system characterised by the lawmaking powers of Parliament and the subordinate lawmaking powers of judges. So at this point, I just want to put a little bit more flesh on these particular bones and see what the judges themselves are saying about their lawmaking powers. This is a huge theme, and I can only make reference to one case, and the judgment of Lord Scarman in a case called McLaughlin and O'Brien, decided in 1983. So I just want to read a couple of quotations from Lord Scarman's judgment and make a couple of comments on how they relate to the themes that we're talking about. So this is Lord Scarman speaking, quote, "Here lies the true role of the two lawmaking institutions in our Constitution. By concentrating on principles, the judges can keep the common law alive, flexible and consistent, and can keep the legal system clear of policy problems which neither they nor the forensic process, which it is their duty to operate, are equipped to resolve. If principle leads to results which are thought to be socially unacceptable, Parliament can legislate to draw a line or map out a new path. The real risk to the common law is not its movement to cover new situations and new knowledge, but lest it should stand still, halted by a conservative judicial approach. If that should happen, and since the 1966 practice direction of the House, it has become less likely, there would be a danger of the law becoming irrelevant to the consideration and inept in its treatment of modern social problems. Justice would be defeated. The common law has, however, avoided this catastrophe by the flexibility given to it by generations of judges." So what's Lord Scarman saying here? No, first of all, he says the role of the two law-making institutions in our Constitution, in other words, Parliament and the judges. They both have law-making powers. He then divides the differences between the two law-making powers. And I'm hoping that you can hear echoes here of Lord Wilberforce's argument in the Miliangos case. I think they're making similar points. By concentrating on principles, the judges can keep the common law alive, flexible and consistent. In other words, it's the job of the judge to develop common law principles, common law rules, and can keep the legal system clear of policy problems, in other words, general legislation, matters of policy, which neither they, the judges, nor the forensic process, the processes of the courts, are equipped to resolve. Now, that's very similar to the argument made by Lord Wilberforce in Miliangos, that the courts are not best suited to making policy, but they are well suited to creating principles and rules at common law. And Lord Scarman's caveat here is if principles lead to results which are thought to be socially unacceptable, Parliament can legislate to draw a line or map out a new path. I mean, what he's saying here is that Parliament, as the supreme lawmaker, can always alter the law if they find that the decisions that the judges are making are socially unacceptable. Note that what he goes on to say. The real risk to the common law is not its movement to cover new situations and new knowledge, but lest it should stand still, halted by a conservative judicial approach. In other words, the duty of the judge is to keep pace with social change, economic change, what have you. And he then refers, interestingly, to the 1966 practice statement, a document we know well. And he says that since the 66 practice statement, this has become less likely. It's less likely that the law would become rigid because judges are refusing to think creatively about the development of principle. The risk for Lord Scarman is that law simply becomes irrelevant. Note that his concluding point is that the common law has avoided this catastrophe by the flexibility given to it by generations of judges. There's, of course, much more to be said about this issue, but I'm hoping that in looking at those two shortish statements by Lord Scarman, we can review a strong claim that Lord Scarman makes about the relative role of the judge as a lawmaking institution, or the court as a lawmaking institution, and Parliament as a lawmaking institution within the Constitution of the United Kingdom.